Shabnam, the first woman likely to get hanged in independent India. But who is Shabnam and what did she do? Hi, this is Chetan and welcome to my legal aid. The facts of the case are Shabnam and Saleem were madly in love with each other and they also wanted to get married. But Shabnam's family was opposed to the marriage as there was difference in their social and economic status. The prosecution case is that on intervening night of 14th and 15th April of year 2008, Shabnam sedated 6 of her family members using tranquilizer diazepam, except 10-month-old nephew Arsh. Thereafter, Saleem killed those 6 members by giving blows on their necks using an axe, and Shabnam killed Arsh by throttling. Shabnam was 6 weeks pregnant when she killed her entire family and later on gave birth to a son in prison. Both Saleem and Shabnam were in their 20s when they conspired and executed the gruesome murders of her family members. Sessions Court, based on the facts, evidences, testimonies of witness on the record, sentenced both Shabnam and Saleem to death. Agreed by the same, both Saleem and Shabnam went to High Court and High Court upheld the sentence. While determining the quantum of sentence for Shabnam and Saleem, the Allahabad High Court considered the mitigating and aggravating factors in their favor and against, the nature of offense, the planning that went into carrying out the murders, and the fact that Shabnam had killed all members of her family, including a helpless infant, were all considered sufficient to treat this case as rarest of the rare, deserving of the death penalty. The High Court refused to consider as a mitigating factor the fact that while in jail, Shabnam had given birth to a child who would be orphaned if his parents are executed. Now let us understand more about the concept of rarest of the rare case. Honorable Supreme Court in Bachan Singh vs. State of Punjab coined the term rarest of the rare, which required judges to use capital punishment only when the alternative of life imprisonment was unquestionably foreclosed. In addition to the nature of crime, courts were urged to adequately examine social, personal, psychological history of offenders, as well as factors such as their prior criminal history, reserving the penalty only for offenders who were unequivocally beyond reform. Now, coming back to Shabnam's case, both Shabnam and Saleem agreed by the judgment of Allahabad High Court appealed into Supreme Court, but Supreme Court dismissed their criminal appeals and upheld the death penalty. Subsequently, Sessions Court also issued death warrant of execution against Shabnam and Saleem. But on 27 May 2015, Supreme Court quashed the death warrant on the ground that both of them are yet to avail their constitutional remedies. Thereafter, a mercy petition was filed by Shabnam under Article 72 and Article 161 of Indian Constitution to the President of India, Pranab Mukherjee, and Governor of Uttar Pradesh, Ram Naik, respectively. On 9th June 2015, the mercy petition was rejected by Governor of Uttar Pradesh. The President of India then rejected her mercy plea on 7th August 2016. On 23rd January 2020, a Supreme Court bench headed by Chief Justice of India, Sharad Bobde, dismissed the review petition filed by Saleem and Shabnam, where the court has found no reason to overturn the death sentence. Recently, on 19th February, Shabnam has filed fresh mercy petition with Governor of Uttar Pradesh, Anandiben Patel, and the President of India, Ramnath Kovind. Considering the recent updates in the case, Shabnam still has left with some of the legal remedies, one of which include a right to challenge rejection of mercy petition before Allahabad High Court and Supreme Court of India as per the guidelines laid down in Shatrughan Chauhan case. And she also has a remedy to file a curative petition against the judgment on review petition under Article 137 of Indian Constitution. Now, let us understand more about the concept of curative petition. The Supreme Court of India evolved the concept of curative petition in the landmark case of Rupa Ashok Hurra versus Ashok Hurra, where the 5-judge bench said that the court, to prevent abuse of its process and to cure a gross miscarriage of justice, may reconsider its judgment in exercise of its inherent power, and such inherent powers are vested under Articles 142 and 137 of the Constitution. In the same case, the Supreme Court also laid down the basic requirement to file a curative petition. The court can entertain curative petition only when very strong reason exists. When in the judgment there is a violation of principles of natural justice, when there is a violation of right to fair trial, where a learned judge failed to bring about and establish the connection between the proceedings and the subject matter, and lastly, when there is an apprehension of bias in the judgment. Considering the facts of Shabnam's case, for an offense to be the rarest of the rare, the emphasis just cannot be put on the brutality of offense, but there should be sufficient proof to show that the convict is beyond reform. The Supreme Court of India has repeatedly held that the imprisonment is a rule and death penalty is an exception, because failure to sufficiently consider the mitigating circumstances will lead to travesty of justice. The capital punishment being the highest form of punishment the state can impose on its people, this process must go through highest level of scrutiny. The next question is that, what if all the legal remedies are exhausted by Shabnam and Saleem, and still the death sentence has not been executed? Such unexplained delay in carrying out an execution will lead to commutation of death sentence into life imprisonment. To answer this question, the case of Shatrughan Chauhan versus Union of India came to rescue. The facts of the case are that the two death convicts filed mercy petition with Governor and President of India. But after 12 long years, their mercy petition was rejected, and such rejection of mercy petition was not communicated with them. In response to this, the relatives of those convicts filed this writ petition. The Supreme Court of India considered the facts and observed that the delay of 12 long years in execution of death sentence results in torture, which is in violation of Article 21. Hence, this can be the ground for a commutation of death sentence into life imprisonment. With this, Supreme Court of India also laid down certain guidelines to follow while execution of death sentence, which are as follows. Solitary confinement prior to the rejection of mercy petition by the President is unconstitutional and should not be adopted. Even after the mercy petition by President, the convict can approach High Court or Supreme Court for commutation of death sentence or challenge the rejection of mercy petition. When the mercy petition is rejected, all the necessary material in relation to the case must be sent to Ministry of Home Affairs. The rejection of mercy petition by Governor or the President should be communicated to the convict and his family in writing. There should be minimum gap of 14 days between rejection of mercy petition and the date of execution of death sentence. There should be regular mental health evaluation of all the death row convicts. Prison authorities should facilitate and allow a final meeting between the prisoner and his family and friends prior to his execution. Compulsory post-mortem to be conducted on death convicts after the execution. If you find this video informative, then do share it with your friends and family. Do like and subscribe to our channel. For regular law updates, do follow us on Instagram. Thank you for watching. Bye bye.